A very good evening, everybody. We all are lucky to have Dr. Aniruddha Rajput with us. So, you all know who he is. Right? So, Dr. Aniruddha Rajput, he is a member of the United Nations International Law Commission. So, we all wholeheartedly congratulate you again. So, I would like to call upon Meek Darshini from NLU Delhi to facilitate Mr. Aniruddha Rajput.
You shouldn't be allowed to.
Yeah. Also, Dr. Aniruddha Rajput, he was the chairperson of the drafting committee for 69th session of the International Law Commission. His areas of expertise include dispute resolution, law of the sea, international investment law and international trade law. He has also taught courses and enlightened young minds at NLU Delhi and also Indian Law Institute, New Delhi. So during 2017, he has been a practitioner in residence at Berlin Potsdam Research Group, International Rule of Law, Rise or Decline. It was based at Humboldt University, Berlin. He was also a member of the study group constituted by Law Commission of India on 2015 Draft Indian Model PIT and a member of 5th Haryana State Finance Commission constituted under Article 243 of the Constitution of India. He is an advocate at the Supreme Court of India since 2006 and his recent book Protection of Foreign Investment in India and Investment Treaty Arbitration was published by Kluwer International. Congratulations once again, sir. Now I would like to call upon Dr. Aniruddha Rajput, please. So you can address from there. You can sit there.
You want to stand, sit?
No, sir, as it may please you.
Well, I'm fine with whatever. What do you guys want me to do? I was not in the mood of standing and giving like a long oration because I barely slept for a few hours last night and took an early morning flight, come out from one brainstorming session into another. But it's a good moment for one to wonder whether the person who is doing the brainstorming has a brain or not. So I'm very delighted to be here. Thank you very much. You can sit,
yes, sure.
please.
Thank you, sir.
So this is my second time being here. The last time when I was here was immediately after my election. And I think I remember the last time when I came, I spoke extensively about how the election campaign happened, what were the different elements involved in the election campaign, my experiences in the election campaign, and then how it played out of the General Assembly. But today I would like to not repeat what I spoke about then, but develop it further as to how my journey has been thereafter. So last year in November I was elected by the United Nations General Assembly as a member of the United Nations International Law Commission. International Law Commission, or the ILC, is a group of 34 independent international law experts. What happened was when the United Nations was created and it was felt that we need to have a way of identifying customary international law. I assume you all have a basic understanding of customary international law. Treaty law is a law which is created by agreement between states. Now when I'm referring to states, I mean countries, not the state of Haryana or state of Punjab. We're referring to countries, that is India as a state or China as a state. Treaties are those where the states get together, write down what they are bound by, and then they are bound by those treaties for times to come. But if we look at the overall structure of international law, or the overall area covered by international law, what comes to our notice is treaties are a very small segment of the overall kinds of laws that regulate relationships between states. And that is very clearly recognized by Article 38(1) of the Statute of the International Court of Justice. So Article 38(1) of 38 sub-article 1 of the Statute of the International Court of Justice, which is a direct copy may be a wrong word to use rather, but which is successor of what used to be the Permanent Court of International Justice, or the Statute of the Permanent Court of International Justice. So the sources, so the principles that have been enshrined in Article 38 sub Article 1 of the ICJ statute are very well recognized as sources of international law. And they've been recognized as sources of international law, not just by the ICJ statute, but by its predecessor institution and its statute, that is the PCIJ statute. The reason why I'm saying and giving this aspect of history is to emphasize the fact that it is very clearly settled in international law what are the sources of international law. So treaty is a major source, but as I said, there are very few treaties. It's very difficult to enter into treaties. In addition to treaties, the second important source of international law is customary international law. Now, customary international law is basically what is manifested in the practice of states. It is two components. The first component is the practice of the states, and the second component is a psychological belief on the part of those states that what they are behaving, the way they are behaving, is actually law, and it's called opinio juris. So the fundamental challenge was how to identify customary international law. The process of identification of customary international law is termed as codification. As we all know, codificatory exercises. What is codification? Codification is fundamentally a process where laws, rules are written down. They're given a form, a written form. Now, when we speak about a written form, what we need to keep in mind is that the words need to express the idea. If we don't express the idea, then the law is an obvious lacunae. The law is insufficient. The law would not be able to satisfy the demands of the time. Therefore, capturing the law in precise words is extremely important, and therefore codification exercise is one of the most important exercises. You are still budding lawyers. I'm sure you must be doing moot court competitions, and you must have realized how much energy of a lawyer is spent at reading, rereading, interpreting, reinterpreting a statutory provision. Therefore, codificatory exercise is extremely crucial. We know even in Parliament they deliberate, or they are expected to deliberate quite a bit on every aspect of a certain law. Now imagine codification of a law which is going to impact the entire international community. Any such exercise has to be done very seriously. It has to be aware, and I'm saying only aware, of the political background and context. And I have said aware. That doesn't mean that the political context or the political background comes into play. It is just to know where does the international community stand at a certain point of time. Codificatory exercise, which is such a fundamental, such an important exercise, is therefore a task of writing down the law. There is another aspect of codification. Codification is basically writing down what the law is, but often the law needs to be developed further. And as I said, for a customary international law to exist, there has to be state practice plus opinio juris, that's a psychological belief that a state is bound by a certain rule. At times it is possible that there is a certain practice, but the practice hasn't developed to the level of a customary international law. Then what happens to that practice? At times, we want the international community to go a step further and take certain position. And we can say that on the basis of past practice and say, well, there is a situation where a certain practice hasn't become ripe enough to become customary international law, but is still in a state of transition. And we feel that this is a good point of time to declare that this particular practice ought to be, or soon to be, a customary international law principle. That is what is called the practice of progressive development of law, where you're trying to develop the law further, trying to expect the law or help the law to take a step further. So codification and progressive development are two fundamental functions which are very important in this framework of the International Law Commission. I think it's only the first time I've used the word International Law Commission after giving the introduction. The reason being, unless we understand what is codification and progressive development, we won't be able to understand the International Law Commission, because all that the International Law Commission is expected to do is codification and progressive development. When the United Nations was created, when the UN Charter came into force, Article 13(1)(a) of the UN Charter, when I say 13, it means Article 13, sub-article 1, paragraph A. So 13(1)(a) of the UN Charter says that the responsibility of progressive development and codification of international law is with the General Assembly. Now, our notion of General Assembly is a body where political leaders come, heads of states come, and at times provoke each other. Has anybody watched the last General Assembly? The exchange between United States and Korea? So if you go by that notion, you might perceive that the General Assembly is a political body. But what you see is just one aspect of the General Assembly. The United Nations General Assembly has 6 committees. I need not get into all those 6 committees, but all these 6 committees perform different functions, from disarmament to budgeting to administration to arms, peacekeeping. So there are several functions which these 6 committees perform. For our purposes as international lawyers, the most important committee is the 6th committee. It is the last committee. Of course, they're not in any form of hierarchy, but it's just the 6th committee, which is also known as the legal committee. It is the 6th committee, that's where all lawyers sit together. And when I say lawyers, I mean representatives of states. There are 193 member states of the United Nations. The representatives of all those 193 member states, and by representatives I mean legal representatives, sit in the 6th committee of the General Assembly, which is also a General Assembly by itself, and discuss legal issues. So the function of codification and progressive development under Article 13(1)(a) of the UN Charter is the function of that 6th committee. Now, as I explained, the members of the 6th committee are representing their country, which means there's always a political component involved in the deliberations. The moment there is a political component involved in any deliberation, the natural outcome of that deliberation is bound to be impacted, because there are always political considerations which persuade or push people to take a certain position or not to take a certain position, which is not a very healthy sign for the entire international community. It was therefore felt by the international community as a whole that it would be in the interest of the international community, in the interest of the world altogether, that we have a community of experts, a group of experts who are independent and experts in international law. These experts could get together, codify and progressively develop international law for us without being influenced by our politics, and then report back to us, which will not just facilitate our work, but will also ensure that there is neutrality in what they produce. Accordingly, in 1947, the United Nations International Law Commission was created. Created would be a wrong word, but there was a resolution of 1947 which intended to create, and the commission actually came into being in 1948. So the resolution celebrated its 70 years last year, and the commission is celebrating its 70 years this year. So that's how I can't resist making this comment. It is going to be a very interesting moment this year, because the commission is going to be in its 70th year, and when the commission celebrates its 70th year in May, the commission would be proud enough to say that we are a young institution even at 70, because I would be 35, half its age. So just to let the world know that we are still a young and a vibrant institution. So although the gap between me and the other members may be quite vast, but it still represents that the commission is a young body to us in terms of its thinking. It wants to have new talent, as long as member states are willing to trust people to take up that position, and the General Assembly is to endorse the competence of such members and make them members of the International Law Commission. Now, therefore, the overall structure is that under Article 13(1)(a), the task of codification and progressive development, which was of the General Assembly, was in a sense relegated to the International Law Commission by its creation in 1948. Now, once the commission was created, the first thing that was done was preparation of the statute of the International Law Commission. When the commission began, if I'm not mistaken, I might get wrong because one is often jumbling with a lot of numbers and a lot of details and one tends to forget some numbers. If I'm not mistaken, subject to correction, I hope I'm not wrong, the number was 15. There were just 15 members of the International Law Commission in the first commission. The reason being there were not more than 50 to 60 member states in 1948. The whole decolonization process started thereafter. And it was only during the 60s and 70s that the number of states mushroomed, and today we have the number of 193. To keep pace with the time, the composition of the International Law Commission was also changed, and the numbers were expanded, increased, the commission was expanded, and the numbers were increased from time to time. Today there are 34 members of the International Law Commission who are elected by the General Assembly. They are based on regional representation. The idea is every region should have certain number of representatives. Asia Pacific group, that's where India falls, that's where I competed for the election from, 7 members are elected. From the Africa group, 7 members are elected. From the Western group, it's called the WEOG, which also includes America, North America, Australia, New Zealand. That constitutes of 7 members. Eastern Europe bloc constitutes of 4 members. So Latin America constitutes of 7 members, and there's 1 floating seat which could go to either of these groups. That's how there are 34 members. Now the idea behind these 34 members getting together is, or that's how the commission works. The commission works between 10 to 12 weeks every year during the summer. I remember when I was about to go for my first session, somebody said, "Don't you think it is so Eurocentric that it happens in Geneva and it's during our summer, so you have to basically put your schedule according to us?" I said, I really don't think so, because I at least get to travel to Geneva. You poor guys, you don't even get to travel anywhere. And one of my colleagues was there, who was also a member of the International Law Commission, and we were at a social event at his invitation. He turned to me and said, "I'm very delighted to see that you don't suffer from the disease of inferiority complex." And I don't think we should as Indians, because we are the ones who have to run the forthcoming century. And if we are not confident about ourselves, there is no way that we can run the forthcoming century. So getting back to the International Law Commission, so we get together during very nice summer. It used to be much pleasant before, now it gets really warm because of global warming in Geneva. Someone might think it's all fun and frolic. When I was about to start my session, I thought I'll also have a lot of time to sort of go around and have some fun in Geneva. One of my seasoned colleagues who had spent 10 years in the commission, he said, "You will realize when you get there." And I think I should start from there. So when I went to the commission, before going to the commission, I had spent 4 months in Berlin. And before getting into these academic environments, I was used to a life of hard-working practitioner. I used to wake up at 3:30, 4:30 in the morning, read my briefs, prepare, go to court. But since the time I had into this academic circle, I had developed this habit, now I call it a very bad habit, of sleeping for 8 hours for no reason, because there's no one who's asking you, demanding you anything. And when I was into the commission, and I was elected as the chairperson of the drafting committee on the first day, and I was back to my routine of sleeping for 4 hours, 5 hours, up at 3:30 a.m. in the morning, reading a few hundred papers, trying to absorb too many things in too little time, and then trying still to be patient to listen to others, understand what they're saying, and then try to convince them, and not get angry even when they are getting angry at you. So it was quite a bit of hard work. It was a good experience. And so I'll very briefly explain how the commission works. What we do is, at one point of time, we have 6 or 7 running agendas, 6 or 7 running topics. For every topic, we appoint a special rapporteur. A special rapporteur is responsible to go study the topic, read it extensively, prepare it fully, and present a report to the Commission in advance. So classically, say by end of January, we start receiving all these reports. We start reading all these reports towards the preparation of the session. We get around 2.5, 3 months to prepare all these reports. We read those reports, critically comment on those reports. A special rapporteur would normally put before you in the report the background of the topic and then propose specific rules or principles or guidelines, whatever are proposed. Those are the exact text of the rules. When we get together in the session, what we do is we divide our day in 2 halves. The first half is called the plenary session and the second half is called the drafting committee session. Plenary is where all 34 of us sit together. It is a public hearing. Everybody is entitled to come, sit, listen to what we say. All that we say is digitally recorded and is put on the web. So if anybody is interested, he or she can go listen to our statements on the web. Often these statements are also used in future, maybe in adjudication or in academic writings, as to how members approached a certain topic. However, plenaries are still policy setting or direction setting in a sense. The discussion is still quite broad. And what happens is, at the end of the discussion in the plenary decides whether to refer the set of rules proposed by the special rapporteur to the drafting committee. At times, or rather most of the times, most of the rules that are proposed are non-controversial, members agree and the rules are referred to the drafting committee. But at times there are tough moments when members do not agree. So we had one occasion when there was voting, there was severe disagreement, and then eventually at one stage, after going through the voting stage, there was another stage and then it was referred to the drafting committee. The drafting committee sits in the afternoon. It sits from 3 to 6. During the drafting committee, every single paragraph, comma, full stop, the word, consistency with earlier practice, you have to be very careful about several things. For example, if in the Vienna Convention on the Law of the Treaties a certain language has been used, and we are working on a similar topic but we use a different language, then there is a possibility that when that provision that we have freshly drafted is being deliberated, if it is different from the earlier text, there is no consistency, there would be arguments raised as to what was the legislative intent or why the Commission did not use the same language. We have to be careful to be consistent with the language, but be also careful about what we are drafting, how we are crafting, and how we are presenting. It is not just the drafting, it is also the ability to capture those ideas and translate those ideas in actual words and present it further. The discussions in the drafting committee are confidential. They're not open for public. Only assistants of members are allowed if the chairman of the drafting committee allows them to come in. I remember an incident where the Japanese member was asking me if his assistant could sit in the drafting committee because he was not a member of the drafting committee. He said, very well, I can probably take her as my assistant and allow her to come in. And then I was talking to the secretary. I asked the secretary, I was the chairperson of the drafting committee. I said, you know, so and so is the situation, so what happens in this? What do I do? He turned to me and said, you should be asking yourself, because it's your discretion as the chairperson of the drafting committee. So the chairperson of the drafting committee has the discretion to decide who attends and who does not attend from outside the members. Now I need to speak briefly about the structure and composition of the drafting committee. I told you in the plenary all 34 members of the commission sit, but drafting committee is voluntary. It is for those who want to give away this fantastic weather of Geneva afternoon, not walk around the lake, come and sit in a room which has no windows, which has an air conditioner which could make you fall ill, and look at other old men. So all those who are enthusiastic for it turn up for this, and trust me, there are many who want to do this. Initially the practice was that prior to 60s, 70s, I don't remember the precise decade or the precise year, but just roughly around up till that time, or probably even up to 80s or 90s, the practice was there was one drafting committee, and it would draft all rules on all topics. With time it was realized that international law has become so diversified, so technical and so specialized that we need different drafting committees for different topics. So we have different drafting committees for different topics. But they decided that at least one person should be made to work really, really hard, and that should be the chairman of the drafting committee. Because the chairperson of the drafting committee remains the same. The drafting committees keep changing, so the chairperson has to read up, keep updated with whatever is happening in all those drafting committees. And then take up topics one after another and ensure that the drafting goes along well. The chairperson has the task of ensuring that the discussion goes on well, giving floor, controlling over-enthusiastic members, ensuring everybody gets to speak. And when I was elected as the chairperson of the drafting committee, I had no experience. It was my first day and they said, fine, we want you to work hard. It's your turn now. So I went to someone who had chaired the drafting committee a couple of years back, a member from South Africa. I said, so what is it? I have no idea what is to be done. He said, I'll tell you a simple golden rule. Your task is to get consensus. And our task as members of the drafting committee is to break consensus. And that was actually the golden rule. And I could see the pendulum swinging from one edge to another. I could see the consensus going in one direction, then slowly somebody trying to grab it and take it in the other direction. And you find out who's that naughty person, cut him, try to convince him and say, everybody is agreed, please, no playing around with the consensus anymore. If you're lucky enough, you get your way through and you get your paragraph through adopted, or no, then there's a whole debate. There have been occasions, I still remember, I hope I have a few minutes to speak. So I remember when it was the drafting committee on immunity of state officials from foreign criminal jurisdiction. And we were discussing which offences would amount to exclusion of immunity, in which situations there would be exceptions to immunity. And there was a debate as to which offences should be there, which should not be there. The special rapporteur had proposed a draft in which apartheid was not there. There were African members and they were very agitated. They said, no, we need apartheid, how can we not have apartheid? They tried to convince, nobody was convinced. They heard, argued, and everybody said, come on, we really don't think apartheid should be there. And everybody was convinced that apartheid should not be there. And we forgot apartheid and we started working. Next day afternoon, because the drafting committee sits in the afternoon, next afternoon when we came back, the member from one of the African members, he said, I'm still very uncomfortable with what happened yesterday. And he made a clarion call, a very emotional call about apartheid. And I was about to say that, come on, you've lost the battle, but I could see that people started requesting for the floor, and I could see the list of speakers expanding. I said, let me see what the reaction is. And immediately, people started agreeing with him. And within minutes, everybody said, yes, we do support the view that apartheid should be included. So what we agreed on the first day was changed on the second day because everybody was convinced. And we ultimately included apartheid. This is a very big lesson for those who don't believe in democracy. Democracy is about consensus. It's not about brute force of majority. Consensus is the ability of the person to use his intellect, to use his logic, and to use his reason to convince those who are not convinced with his views and his viewpoints. One must try very hard. But if one fails in convincing others, one should be gracious enough to step back and say, that's fine, I tried my best. But there can be no alternative to consensus. Consensus is fundamental. It just can't be brute force of majority. And by brute force of majority means in all fields. The brute force of majority always comes in when there are ideological battles, when people fight battles on ideologies. There's a need of conviction about a certain point of view and persuading others and not using violence for it. Sorry for the digression, but that was my takeaway from the commission, and that's what I used to say. I am an Indian and I am fundamentally a Democrat, because I don't believe that there can be any way in which violence can be a way to convince anybody else. The way to convince is reason and logic, and I have seen reason and logic working very effective and efficient. And I was explaining it to somebody, and I was saying that this is what the Indian tradition is all about. The Indian tradition is vade vade jayate tattva bodhaha. We debate in the search of truth. Don't debate as a propaganda. I made a very brief comment in the beginning about social media. When I see these Facebook posts, I feel disturbed because it's propaganda. It is one person's propaganda versus somebody else's propaganda. How much is real reason? We need real reason. Sorry for the digression, but I really couldn't resist myself. But that's where I see, and that's the beauty of the commission, that's the strength of the commission. That the commission, despite its differences, we fight bitterly with each other. To be very honest, we fight bitterly with each other, but we respect each other, we respect each other's views. And if our view doesn't get carried, if somebody else's view is carried, we equally graciously accept the view which has been so accepted by all others. Let me just move to the final limb of how the commission works. After we do that, so the drafting committee is confidential, nothing is in public domain. The chairperson of the drafting committee is to go back to the plenary and make a presentation to the plenary. So there is a statement which is made to the plenary saying what we did in the drafting committee, why we adopted certain provisions, why we did not adopt certain provisions, which then constitutes the travaux, that's the legislative intent. What was the intention behind accepting a certain language? What was the intention behind adopting a certain text and not adopting another text? I remember how drastic transformations have texts undergone in the drafting committee. On one topic, I think we went in with one provision and we came out with 3 provisions. On another topic, we went with 2, came out with 1. So there's a lot of transformation which happens in the drafting committee, and which is a place for ideas, and ideas where